amount of case law in school and another.
Thank you. Sorry we're slightly late. There's so much to talk about in a case like this.
Yes, imagine. And I had that firmly in mind in terms of timing. Can I just say what I'm proposing to try to do, which is that I was giving you yesterday an analytical framework, which I'll return to in a moment and complete it. And my aim is to complete that by around 11 o'clock, to deal with the remission points directly over the course of the following half an hour, and then cede my position to Mr. Milson to make the points that he needs to make. So that's the timetable broadly that I'm working
Fine. Well, if you stick to that, if we let you stick to that, there'll be no problems.
I'm very grateful. So yesterday I was outlining 3 different approaches which might be taken to a case involving the manner of manifestation. The first was that they could be treated as indirect discrimination cases. And I've taken you to a number of authorities. I want to round up that first limb very quickly now by doing, perhaps for the first time in my career, something unexpected by referring actually to the skeleton that I have put in this case. Paragraphs 34 and 33 deal with the EHRC guidance, and you'll find it set out at paragraph 34, placing limitations on a person's right to manifest their religion or belief may amount to unlawful discrimination. And this would usually...
Sorry, James, you're, as yesterday, you're dropping your voice again.
So sorry.
It's not just me.
Well, perhaps if I can invite you to look at
Are
paragraph
you feeling
34.
better, by the way?
I'm comforting myself that I'm at the bottom now. So it can only get better from here. Excuse me.
Right. Sorry, 33 and 34.
33 and 34 are Gould and the HRC guidance.
Sorry, it's quite difficult. Not Justice Linden is always pellucid. I find it quite difficult to. Give me one more minute. Yes, I see.
So,
I mean, manifestation is the more one thinks about it, is an ambiguous term, like every other term in this field. In one sense, if you go out into Trafalgar Square and say, I'm a Christian, you are manifesting your belief. And if someone then arrests you for it, or that is direct discrimination. No, sorry, but that's a very bad example. But still, that you're like if you suffer a detriment for a public statement of your belief, distinguishing between the manifestation and the belief is sort of meaningless. The one is the other. If you do something which is not overtly a statement of your belief, but is conduct from which is motivated by your belief and establishes that you have that belief, you saying that if you're then suffering detriment for that reason, that will only be indirect discrimination?
We are saying that manifestation cases ought to be dealt with as indirect discrimination cases.
All manifestation cases?
We think, but the key point in this case, of course, is whether manner of manifestation cases, which I'm going to suggest to you in a moment, is a further distinction, should be treated in that way. You raise a very important point, which is not all manifestations, even if they're in some sense closely connected to or motivated by a belief, are a statement of the belief, which is why we think, you'll recall when I went through the taxonomy, there are cases where it's open to a court or tribunal to conclude that the reason why, in the employer's mind, is the belief, even if the immediate factual context is a manifestation. So you recall I said if you went into work wearing a t-shirt which said, I believe in same-sex marriage, or I don't believe in same-sex marriage, and the employer said, well, I never knew that about you, but now I do, you're sacked. The manifestation, of course, is the but-for cause of the decision, but it's pretty clear that the reason why the dismissal takes place is because there's an objection to the belief itself. And there will be some manifestations. You could have a pure manifestation of the belief, which might be, for instance, thinking about church on a Sunday, when you stand up and recite the creed, you are saying, this is what I believe. So that's a public manifestation of the pure essence of the belief. And in those circumstances, I think if you are treated less favourably because of it, then that would be direct discrimination, because it's clear that it's the belief that is the reason why the action is taken against you, albeit that it arises in the context of a manifestation. So what the reason why test allows us to do, I think, and it's an incredibly useful flexibility, is it allows a court or tribunal to look at all of the facts and ask itself whether on these particular facts this is really about the belief or it's about something separable from the belief. In some cases the manifestation will be separable and in others it won't. So to give you an example that I was going to come to, in other words, your decision in McFarlane and late Avon is a case where the manifestation, as in Liddell, is a refusal to do certain sorts of work.
That was a marriage counsellor who wasn't prepared to give certain sort of counselling to same-sex couples.
Exactly right. So, I mean, it's clear that that's a manifestation of belief because the employee said, I'm doing this because of my religious beliefs. I'm not prepared to perform this function as a result of the Christian belief I hold in relation to the nature of marriage. So what was argued in front of you in that case was because this is a manifestation of a religious belief, you cannot logically separate out the manifestation from the belief itself. This is someone whose beliefs require them to act in this particular way. It must follow that if you treat them less favourably because they have acted in that particular way, you are also treating them less favourably because of their belief. And that's a position you explicitly reject. And perhaps I could invite you to look at Bundle 5, page 55 of the Authorities Bundle. And it's paragraph 17 and 18. At the start of paragraph 17, you set out reasoning in relation to a direct discrimination claim. You say the express finding of the tribunal that the reason why the claimant was treated as he was not because of his Christian faith, but because of his perceived unwillingness to provide psychosexual therapy counselling to same-sex couples. And thus, this being the other side of the same coin, that he was treated in the same way as a non-Christian who had evinced such an unwillingness was clearly open to the tribunal on its facts, if not indeed inevitable. So you'll recall yesterday I was saying that ordinarily understood, the comparator test in a case of manifestation of belief is what if the person had done the same thing, the same conduct, but not because of the belief. Now, to come back to your point about Trafalgar Square, there are going to be some cases where it isn't in practice possible to draw that distinction because the conduct consists only of manifesting the belief.
Yeah.
But we think there's no argument from our side that that wouldn't be an act of direct discrimination. But the question for each court or tribunal is, applying the ordinary separability principle and the ordinary test for comparison, what was the specific reason here? So you'll see that what's then advanced at the bottom of paragraph 17 of the last sentence, the argument that is put to you is the importance of protecting not merely the right to hold religious beliefs, but the right to manifest them in conduct. So here's a recurrent theme of both his and Mr. Diamond's submissions. The two are, they submitted, inseparable. And you respond, we cannot accept this argument. It is of course correct that persons with a religious belief are likely to manifest that belief in their conduct. We further accept that in some cases where an employer objects to such a manifestation, it may be impossible to see any basis for the objection other than an objection to the belief. So that's the point I've just made. There will be cases in which that is true. And in such a case, a claim by the employer to be acting on the grounds of the former but not the latter may be regarded as a distinction without a difference. But in other cases, there will be a clear and evidently genuine basis for differentiation between the two. And in such a case, the fact that the employee's motivation for the conduct in question may be found in his wish to manifest his religious belief does not mean that the belief is the ground of the employer's action. So we say, this is, without wanting to sound too much of a creep, a model approach to this issue. It is saying, in a direct discrimination case,
Flattery will get you everywhere.
You focus on what the actual reason is, and it's a fact-finding exercise.
I am, however, so modest, I hadn't read this passage probably since I read it, but yeah, okay, well, it is obviously on point.
So,
is this the case where permission was refused but in a quite extensive judgment by Lord Justice Laws?
it is.
I remember very trenchant terms, but maybe not relevant on this point.
No, not specifically. I think principally arises from what comes next. So in paragraph 19,
keep going, sorry.
In paragraph 19, the argument put to you is that you should approach this issue by analogy with web and emo air cargo. It says, the argument as it's formulated before you is building on web. Similarly, it was argued, this is at E, a faith-based objection to counselling same-sex couples could not be equated with an objection based on other grounds. We do not believe that the court's reasoning in Webb, which was very specific to the case of pregnancy, can be extended into other situations. So what was said, in effect, is that, well, religion is special here. You shouldn't just treat it as being like any other conduct. You have to bear in mind that it is faith-based, and that requires different treatment. So rather than simply saying, well, anyone else who had also refused for some other reason to counsel same-sex couples would have been treated in the same way, that is to leave out of account a special factor requiring, in effect, a special comparison. And you go on at 20, having rejected that argument, to say there is no inconsistency between that conclusion and the requirements of Article 9 of the European Convention on Human Rights. So that takes me to the end of what I wanted to say about indirect discrimination as an approach. In McFarlane, obviously you'll see at 57, it goes on to be considered on an indirect discrimination basis, and then justification becomes an issue. Of the three approaches that one can take, the second approach is really the one I've just urged upon you, which is a focus on a purely causal and purely factually causal question as to what the reason was. And to make that point, or to illustrate that approach, I'm going to invite you to have a look at Kong and Gulf International Bank, which is a Court of Appeal authority which subsequent to page, you'll find it at 8, volume 8, page 153.
Sorry, can you say that again? Volume
8, page 153. Kong is a whistleblowing case, and the reason why that's significant, of course, is that in whistleblowing cases, Article 10 points may frequently arise. It's a case in which an argument was put before the Court of Appeal that there should be, in determining the question as to what the reason for dismissal was, so it's the dismissal part of the claim that we're focused upon, what I'm going to describe as the sort of hybrid test that the EAT has used in this case. In other words, rather than look purely at the factual question as to what the reason for the employer's decision to terminate was, there was an attempt to introduce an objective reasonableness standard. And we can see that, picking it up, please, at page 169 of the bundle, at paragraph 40 at H. In fact, it might help. I'm going to start, if you don't mind, at 39. Mr. Young is making the submissions. It says, Mr. Young submitted that the question of separability is an objective question for the tribunal to answer. So rather than an analysis of the subjective intentions, it says, and the test is the same for both claims. Those were the detriment and dismissal claims. Once answered in relation to the detriment claim, the decision applied to any other decisions taken because of the content of question. Although his submissions at one stage appeared to suggest that he was contending for a rule of law, deeming the employer to have had a reason they did not have, Mr. Young contended instead for an evidential rule. So just pausing there, it seems Mr. Young recognised the danger of the direction in which he was heading. It's the danger we say exists in this case, that one doesn't want to end up in a position where one is applying a test which says whatever your actual motivation was, whatever your actual reason why was, because we've applied an objective reasonableness standard, the AT says here required by Article 9.2, we effectively deem you to have had that reason why. At paragraph 40, you'll see at 8 it says Mr. Young's primary submission was that as a matter of law, it would be a failure to apply the relevant principles correctly if conduct that amounted to no more than ordinary unreasonableness could be separated or distinguished from the making of the protected disclosures themselves. So that's the proposed hybridisation in the argument made by Mr. Young. He's saying, well, don't just ask whether or not the reason was the making of the protected disclosures. Ask first if the supposedly separate conduct that is being relied upon by the employer under the separability analysis is unreasonable or not. And if it's not unreasonable enough, then you should treat it as not being capable of being distinguished from the protected disclosures. So you effectively deem them to have taken the decision on the basis of the disclosure themselves. Now that argument is disposed of, and that analysis is disposed of in paragraphs 56 to 57 of the judgment. May I just invite you to read those rather than having to read them out to you. You might like also to read the first part of paragraph 58.
The passage she's endorsing is from that case, which I never know how to pronounce. Is it fake it or feck it?
We were going with fetch it, but fetch it.
Yes,
Might
okay.
well be
Right,
fetch
but
it.
anyway, that Lord Justice Elias. Fetch it. Yep, okay, thank you. but I've actually read to the end of 59. Yeah, well,
I'm grateful. So, what we say is being said here in the light of page, which is cited, is it is a pure causation, factual question. You don't need to say if the conduct you're relying upon is not unreasonable, then it can't be separable. The question is simply, are you relying on the conduct rather than on the disclosure? And the analogy for this case is something similar is proposed by the AT. What they say is, well, when I'm asking what was your reason for termination in this case, first we ask, in effect, how bad is the conduct? And the reason why that's relevant is it would go to the question of proportionality. The worse the conduct, the more likely it is to be proportional to dismiss. And if what is required is that you establish that the proportionality analysis would be determined in your favour, which is what the AT seems to require, you're inevitably focusing on the question of the reasonableness, potentially, of the conduct of the claimant, but also inevitably on the reasonableness of the response of the employer. And neither of those things is, we say, a sensible guide for the reason why the thing is done. So, well, I should qualify that in this sense. What it seems to me that Kong is underscoring in its analysis of Martin, we entirely do accept, which is that, of course, it is open to a court or tribunal to say, well, the more disproportionate your response appears to be, the harder you're going to find it to persuade me that it was a separable matter rather than the belief or the manifestation of the belief itself. Or in this case, the harder you would find it to persuade me that it wasn't the protected disclosure itself rather than some separable matter of conduct. So it's what was described earlier in the decision in characterising Mr. Young's submissions as being a sort of evidential principle. And that seems to me not only to be unobjectionable, but vital. It ought to be available to a tribunal or a court to look at the reasonableness of the conduct, the reasonableness of the response in the light of that conduct, as an indicator as to what the reason why was, but without losing sight of what ultimately the question is, which is a pure one of fact. What was the employer's reason for doing what they did?
as to the relationship with Article 9.2 and the proportionality test there, which is the test,
Yeah.
is this what you would say that, and I think actually this is roughly how we put it in Page, though I'm not sure I know we didn't have such profound submissions on it as we've had here. This will, at least on the facts of Page, and in most cases, produce the same result as would be produced under Article 9.2,
Yes.
and that is desirable.
Yes.
But it's not the same as assimilating the two tests, blending them, as Mrs. Fraser Butlin would say. That does leave, though, the possibility that in some cases there will be though not perhaps in the generality of cases, there will be a mismatch between the outcome you would get
Yes.
in a convention claim and under the Act on your interpretation.
Yes.
What do you say about the proposal that needs to be bridged by the application of Section 3 in such cases?
Well, let me identify specifically the circumstances. Where that will be a problem is where the court or tribunal is convinced that the reason is not the belief or the manifestation, but a separable matter for the conduct. Say in this case, the language in which the posts are expressed and the risk that creates of infringing the rights of others. But the tribunal takes the view that it doesn't rise to the level necessary to engage Article 9.2. So they've made a finding of fact as to what the reason why is, which is what happened in this case. But they now have, on on the basis of the approach proposed by some of the interveners, to revisit that question and effectively deem the reason why to be something else because the objective standard is not met. Now that, I think, is just going to be, if you take that approach, is the inevitable consequence of trying to meld together two entirely different approaches to how you protect Article 9 rights. If you're going to take, as we have taken, a discrimination approach, and that we're all satisfied, as we appear to be, as a result of Mumbar and other authorities, that there is no sort of freestanding right in the tribunal to be complaining about a breach of your convention rights, then the only cases that are going to be protected are ones where the tribunal is satisfied that there is some discrimination. And that will involve, in direct discrimination cases, the tribunal being persuaded that if someone else had done the same thing but without the belief, they wouldn't have been treated in the same way. Or in indirect discrimination, if that's the path that is taken, that there's the necessary suite of disadvantages and that there is no justification for it. Is it possible that you could fall between those two stools, that you might have a case that was, you couldn't win either on direct discrimination or on indirect discrimination? Well, the answer is, it seems to me, just as a matter of abstract logic, yes, because this is a discrimination approach to dealing with convention rights, and it differs in that respect to how the convention sets about protecting convention rights.
That point is made very explicitly by Advocate General Sharpston in Bugnaoi.
Exactly, yes.
Don't know whether, we haven't looked at that yet, but I don't particularly want you to take us to it unless you want to, but that, don't know whether her approach was approved by the court, as far as one can ever tell what the court thinks about what they said.
I couldn't tell when I looked, but I mean, others may have a stronger view, and I'm conscious that I'm straying into what others are going to be dealing with when I promised I wouldn't, but I thought it was important to make that point now. What the EAT does is to, in a single test, marry together two fundamentally different approaches to the protection of Article 9 rights and Article 10 rights.
Could I just ask one other question? You may say this is also a question. When you say others, you mean Mr. Milson?
Mr. Wilson, but it also features very heavily in the intervener's submissions.
Yes, I suppose so. But do you have any observations? I'm not cross-examine you about them, but just in case you want to, about the alternative proposal put forward by the Free Speech Union, or by Mr. Cooper on behalf of the Free Speech Union in his written submissions, where he proposes a reconciliation based on, the headline is the scope of the protected characteristic of belief, and then that's analysed rather more fully later on in the submissions. Maybe you want to depute that to Mr. Milson, but...
Well, I do, but broadly speaking, it seems to me to be a rather artificial way of looking at it, because you effectively can't determine whether... At the moment, the problem is you're prevented from determining the question of fact as to what the employer's motivation, to use the Martin Devonshire's label, is until you've decided a justification issue. So, on the Free Speech Union approach, it moves that difficulty one stage further forward in the analysis. So you effectively can't decide whether someone has a protected characteristic until you've decided a justification issue. And I can't see how that's going to be sensibly possible for tribunals to be applying. But worse still, given that the idea is to have an approach to the law which lends itself, if not intuitively, then subject to some basic training, to the kind of people who are having to take decisions on a day-to-day basis about this within the workplace. It's a potentially elegant, but it seems to me artificial, and for the ordinary person quite difficult to follow notion of whether someone has a protected characteristic or not.
Thank you.
It also, if I remember rightly, and it's been a while since I've looked at it, it depends on, to some extent in the analysis, on a slightly odd trick of language, which says, or to be of a belief means to be more than simply hold a belief. It means to be manifesting that belief too. But one might equally say that wanting to be glib about it, but I'm of the opinion that that is a very unusual way of approaching, interpreting that particular form of English phrasing.
Yes, I hadn't picked that up, but I looked at it again. Thank you.
So that brings me to the last approach, which is effectively the EAT's approach here, which it says it derives from Page. Others are going to be dealing with Page, I suspect, at much greater length. But I just wanted to touch on it for a couple of points, and also because of the council suggested it might be helpful if I introduce it at this point. Can I ask you please then to have a look at bundle 7, where Page is to be found at, and we're going to start please at 437. Now, you may recall that there was an argument before you as to whether, when approaching cases in which Article 9 might have some potential applicability, there was an obligation effectively to start with an analysis of whether or not Article 9 had been breached, and then move to the question of discrimination. And the position that the court took in relation to that matters, there wasn't necessarily any particular order in which things had to be done.
That's certainly, we were showing this passage yesterday, and it reminded me.
But it was
It's obvious. Anyway, as always in these cases, you've got to look at the point that was being argued.
Yes.
It was being argued there was a rule one way, and we said, no, that's fine. Didn't mean we said there was a rule the other way.
No, and I'm not going to suggest that there is.
No, I know. But sorry, I'm just spelling out the point I think you were about to make to me. Yeah.
I'm grateful. You and the court concludes at paragraph 50 that Article 9 is engaged. Although you were unsure at paragraph 51 as to whether a particular argument was in fact open to be run in terms of what the belief was, but nevertheless that proves not to be determinative. And you turn at paragraphs 52 and following to the question of justification. So just pausing there, there's no rule as to in which order things are addressed, but as a matter of fact, what happens in the Page decision is the Article 9 issue is engaged with first.
Yeah.
And at paragraph 59, please.
Yes, I think that just reflected the way in which it appeared in the grounds of appeal.
Yes.
Yeah.
So, and looking at the balancing exercise, for instance, you are looking at 59 the question of the language or the terms in which the opinion had been expressed. You say it's also right to acknowledge that he expressed his views in temperate terms. And then you identify 3 reasons for upholding the tribunal's conclusion that the proportionality balance comes down in the authorities, the respondent.
Well, again, let's be, the way it was expressed was holding that it was a conclusion to which the Employment Tribunal was entitled to come.
Yes.
Yeah.
And 3 key paragraphs, 60, 61 and 62, and perhaps I can invite you to refresh your memory as to what those say if you haven't read them very recently.
Well, I think we all have, but we'll quickly look at them again. Yes.
So starting at 60, and bearing in mind that in this case...
One isn't really, in a sense, one is in a sense preliminary to 2 and 3.
Yes.
It's just spelling out that the views were wider than they had been characterised.
Wider than they had been characterised, and ones which were, quotes, more likely to cause offence or invite misinterpretation.
Yes.
Which it seems to me must be relevant to balancing exercise, but you'll know better than I whether they were taken into account. At 61, this this is not just a case that,
You have to read that obviously with the following sentence. That's not enough by itself.
no, so it's all three matters, as I understand it, that are relied upon in determining the proportionality question. You find that it was not just the case that some would find that what he said, disturbing or offensive, but that it could have a real impact on the delivery of healthcare. And pausing there, I just pause to notice in the light of some of what Mr. Adair had to say yesterday, this doesn't seem to be a case in which the Trust was required to prove that it was having that effect, to produce evidence, to say, here are people who have not engaged with our services as a result.
Well, I think a point I make somewhere is that, in fact, Mr. Diamond never challenged that finding, and when asked whether he challenged it, said that he didn't.
Yeah.
So there wasn't really any examination of how soundly based that was.
I agree. At 54, the way in which it's put is that they had a genuine and reasonable concern that this might happen. But insofar
Well, again, that was a finding the tribunal made, which wasn't challenged.
yes.
Yeah.
But the significance from my point of view is no one seems to be saying in the course of this case, as Mr. Adair now seems to be saying, saying in the course of Page, as Mr. Adair now seems to be saying, well, that's never going to be enough. It can't be enough that you have some speculative, as he put it, concern that a bad thing might happen. You need to turn up and prove that it has happened. And that doesn't seem to have troubled anyone in this case, including Mr. Diamond.
Well, you may be right, but I think you mustn't overinterpret the authority. The point was, at a point to which we specifically drew attention, there was no challenge to that finding by the tribunal.
Yes.
So, in terms of any authoritative value, it's rather neutral.
And then finally, there's the point about the appellant's own conduct making it practically impossible to find a way forward that would have respected both parties' interests. But arising from those three considerations is the conclusion that the tribunal was entitled to reach the finding that it did.
Yes.
Now, because the finding that the tribunal has reached is that there is no breach of Article 9, once you have upheld their decision that there is no breach of Article 9, we say that technically no question then arises in approaching the Equality Act as to whether or not it conforms with the Convention, because there's already been a determination that the Convention has not itself been breached. And the reason why I raise that is it seems to us that there must then be an argument that if what you go on to say in this judgment is what Mrs. Justice Eadie believes you went on to say, that it would be technically obiter, because the question as to how purposively to interpret the Equality Act doesn't arise once there's been a decision that there's no breach of the Convention. The passage that we say is key is, and which the Employment Appeals Tribunal certainly seems to have thought was key, is paragraph 68 at page 442. And I know this has been read to you already, so I'm not going to read it again, but I'll pause for some refamiliarisation.
Yep.
And it seems to us that what is being said, particularly after the number 2 at 68, may be capable of two interpretations. One of which is that given to it by the EAT, which is that when it talks about justifying the act complained of, what the Court of Appeal had in mind was justification in the strong sense of ensuring that a justification defence of the kind envisaged in Article 9.2 was available, or it might, rather less dramatically, simply be saying, making the point that we discussed earlier, which is that there's in effect an evidential approach, which is the less justified the response, the harder it's going to be for a tribunal to conclude that there's any actual separation between the objection which has been identified and the belief itself. The latter interpretation we think is, as I said earlier, not only wholly unobjectionable but positively necessary for dealing with cases fairly. Of course, the tribunal's entitled to look at what an employer did with a view to seeking to draw inferences about what was in their mind, always subject to the warnings that mere unreasonableness is not itself determinative, but the more unreasonable behaviour is, the harder it's going to be to convince a tribunal that your motivation didn't involve the protected characteristic. There is some forensic, as it were, evidence that this approach is what you had in mind, one of which is a footnote to paragraph 6. It's footnote 6, sorry, to paragraph 69, which we find at 452, which is where you make cross-reference to McFarlane, your decision in McFarlane, which we looked at a few moments ago, which is, we say, a perfectly orthodox application of the ordinary direct discrimination comparator test and the separability analysis. You also make reference to the line of EAT cases which involve Chondle, Grace and Wasney. And given time constraints, I'm not proposing to take you through them, other than to invite you, when you retire, if you feel it necessary, to look at them again. But what we would say about them is that what they establish is that they are sceptical in the three decisions about a distinction between belief and manifestation. They all accept a distinction between manifestation and manner of manifestation. They all seem to treat it straightforwardly as a causation issue. Only one of them, Wasney, makes a reference to Article 9.2 at all, and none of them apply a Bank-Mellat style analysis, even though Bank-Mellat, in fact, I don't think Bank-Mellat is even cited in Wasney, even though Wasney is post Bank-Mellat. So that line of authority is certainly authority for the proposition, for the principle of separability, but none of those cases seem to us to say you have, in order to read the Equality Act in a conforming manner with the Convention, to read in an objective element into what was otherwise a subjective question of the employer's intention. And unless I can help you further on that, I was going to move to the remission questions.
Yes, just one further point. Although we refer at para 74, I refer at para 74 to the desirability of a correspondence between domestic and conventional jurisprudence, and somewhere else briefly to section 3. What do you say about the argument that this isn't really a section 3 case, because the rights conferred certainly on the person with the belief are, on your analysis, more fully protected than by the Convention? If anyone loses out, it's the putative, which the discriminator, or
Yes.
Under the Convention, the actor. So it's not really a case where Section 3 is engaged. I mean, the jurisprudence generally is clearly on the same point, and it would be desirable that they correspond. But it's not pure Section 3. Now, I'm not endorsing that argument. I've seen that referred to in the submissions. I just want to know what you said about it.
Well, that is something that Mr. Milsom is going to deal with specifically. So,
Right, okay.
with your permission, I'll
Okay.
defer the gratification of an answer to
No.
that.
Yes.
Right. So, turning to the question of remission, and the most important of the submissions, which was, ought it in effect of being so obvious that a justification was not going to be made out, that there was no point in remission at at all. And it's put differently in the skeleton to how it was put orally. So in the skeleton, he runs through a number of individual factors and was originally intended to respond in kind. But it was put on a broader, more general way yesterday. So that's how I'm going to deal with it this morning, with your permission. And it seems to me that one way of looking at it is simply to say, well, let's look at Bank Mellat and let's look at what the tribunal would be looking at, and then ask whether it's possible that they might make a determination in the favour of the respondent. So the first of the Bank Mellat questions is the objective of the measure sufficiently important to justify the limitation of a protected right? And in looking at a belief case and at an Article 9 case, you look, as one would expect, at 9.2 to see what are the things which the Convention has recognised as being potentially sufficiently important to justify the limitation of a protected right. And the answer in this case is it's the protection of the reputation and rights of others.
Protection of the what and right?
The reputation and rights of others. So that's the formulation from Article 10. The rights of others is one of the matters which is identified in Article 9.2. We know that's what the employer had in mind, because at supplementary bundle page 33, we have the dismissal letter, and you'll see there's a heading Human Rights on that page. And they say right at the bottom that secondly, your rights under the ECHR and the HRA are not absolute, unfettered rights. Those rights are subject to limitations and can be overridden where necessary in a democratic society. For example, for the protection of the reputation of the rights of others. We concluded that the posts were not expressing moderate views, and as such it was legitimate for the school to impose restrictions on your rights. So I promised you yesterday that we'd look at a case called Giniewski, which you'll find at bundle 4, page 165.
Yes.
Now this is an Article 10 case, and you'll see the facts at 165. It arises out of an article that was published discussing a papal encyclical, which seems to suggest that it was in some sense because it contributed to anti-Semitism and may have helped lead to the Holocaust, as a result of which an action in a form I don't really understand, an offence of public defamation, was brought against the author. And the question, the author said, relying on Article 10, was whether the finding against him of liability for defamation had interfered with his freedom of expression. So I don't pretend that it's on all fours with the facts of this case. I mean, it's obviously very different. But there is an important passage at page 177, paragraph 43, which is dealing, I think, with an issue of general principle, the question of what is and is not necessary in a democratic society. What I'm going to suggest to you is that there are effectively two boundaries to what can be done by way of freedom of expression, or indeed the manifestation of religious belief. The outer boundary is if the belief you're manifesting or your expression infringes Article 17. It's just not open to protection at all.
Yep.
But there's a sort of inner boundary, which is implicit, of course, in there being a justification defence in Article 9.2 and 10.2, which deals with cases which, on the face of it, involve beliefs or expressions which are protectable, but which in the particular circumstances justify some infringement. So at paragraph 43, they say as the court has stated on many occasions, freedom of expression constitutes one of the essential foundations of a democratic society. That was a point made to you repeatedly yesterday, and just in case there's any doubt, we do not disagree with that proposition. and one of the basic conditions for its progress and for each individual's self-fulfilment. Subject to paragraph 2 of Article 10, it is applicable not only to information or ideas that are favourably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock and disturb. So again, point made repeatedly yesterday, we don't disagree with that at all. But notwithstanding that, you'll see that the Chamber goes on to say, as paragraph 2 of Article 10 recognises, however, the exercise of that freedom carries with it duties and responsibilities. That's building on the specific wording of Article 10. Amongst them, in the context of religious opinions and beliefs, may legitimately be included an obligation to avoid as far as possible expressions that are gratuitously offensive to others, and thus an infringement of their rights, and which therefore do not contribute to any form of public debate capable of furthering progress in human affairs. So, yes, you may express views and beliefs which offend, shock or disturb. Yes, we agree that you can do so in punchy language, but there is a limit. And that's the limit which is being set out here. That if what one has is, you know, a perfectly protectable belief or opinion which is being expressed in a manner which is gratuitously offensive or in a way which is really incapable of advancing public debate, then that may be a different matter. And can I just pause there to say this? We agree, of course, that freedom of expression and freedom to manifest belief is essential to producing a pluralist and tolerant society. And we don't disagree that the production of such a society is in major part the purpose of the Convention rights and is a matter that tribunals are entitled to take into account when assessing balancing exercises of this kind. But one needs to be clear about what that would look like. So it would not look, we say, like quite a lot of modern online internet debate looks, which is a polarised polis in which people address each other rather in the manner of artillery exchanges from within a bubble within which everyone agrees. That's not advancing public debate. I'm not saying that people are not entitled to engage in that behaviour at all, but what we shouldn't pretend is that you produce a tolerant society by effectively allowing polarised positions to gratuitously offend each other and accuse each other of eye-watering acts of misconduct. So there is a limit. It's recognised that there is a limit, and it's set out there in Giniewski. And there is, one might have thought, something of an echo of a distinction between what is being said and the manner in which it is being said, appearing here in this analysis of the justification of infringement of an Article 10 right. So could I also ask you quickly, please, to look at Bundle 7, page 364, which is the Lillendorf
Just
case.
before you leave
Yes.
this case, Mr. Jones, in a case of this kind, who decides whether it's gratuitously offensive?
So in a case of this kind, which, because from our point of view, we only get to be answering 9.2 and 10.2 questions at all if the AT is right, that it's something the tribunal must look at, it would be the tribunal. So I accept that this is an objective test.
And do they?
Sorry?
Did they in this case?
Well, they didn't in this case because they weren't asked to adopt a proportionality analysis of this kind. They approached it on, we say, the correct basis, which is, because this is a discrimination case, what was the employer's reason?
And my lord may want to continue his line of questioning.
The employer's reason appears to have been that someone might reasonably take the view that the views expressed were homophobic and transphobic.
Someone might reasonably, and someone had. But essentially, yes, the language had created that reasonably foreseeable risk, as it were, that people would interpret it as homophobic and transphobic. Not because of the belief, but because of the manner in which it was expressed.
We know that one person did
Yes.
complain it. But the tribunal didn't endorse that view, as I read there.
Well, I agree because it didn't have to, but it wasn't asked. It's the point of the remission now is to ask it to do that. And I'm not allowed to argue to the contrary because I don't have permission to appeal. But if I had, you could probably guess what it is I would be saying, which is that they got it right.
If, as you say, the tribunal didn't decide this, and that's why the EAT has remitted it, but we're being invited to say it's unnecessary to remit it. And the discussion yesterday was on the lines that this is a pure Jaffrey case, and therefore what we should be asking is it obvious that, well, no, I'll use Jaffrey now, is there only one possible answer to that?
Yes.
Is that a factual question, or is it a question of law? By which I mean, is it enough that we think that we have all the material with which to answer that question, and we should therefore answer it for ourselves? Or should we be taking the more restrained view that there's an element of reasonable evaluation here, and we should leave that to the tribunal unless we think that no reasonable evaluation could find justification?
Well, the latter.
I thought you would say
Yeah.
that. Is it self-evidently correct?
So is that proposition self-evident?
Yes.
Correct. I think so, for a number of reasons which we have set out in the skeleton. So you'll see in the skeleton we identify a number of factors which I won't, given the time, read out to you, but I'm going to ask my learned junior to remind me what the paragraph number is. But I think what it really comes down to is this. I am conscious that I'm in a position where I didn't appear below in either case. Neither did my junior. I don't know what I don't know about what was said in evidence and what was in the tribunal's mind. So it's likely that the tribunal did have at least a preliminary view as to whether or not this might be justified. Indeed, it is the appellant's case that, because of what they say in relation to a hypothetical employment tribunal unfair dismissal claim, that it's so evident what they would have decided that that's what allows you to make the decision.
I think I may be being confused, but I thought at this stage we're just looking at the posts and applying the case we were just taken to, whether they're effectively gratuitously offensive, whether they contribute to public debate. Those are written documents, and the ordinary approach of the courts is to say, well, courts on appeal can look at those written documents, they certainly do to interpret them, and indeed that's technically a question of law, they can do that just as well as a lower court or tribunal. So I'm struggling a bit with this, I have to say.
Well, no, I see the point, and I'm sensitive to it. It's right that we're focused on posts.
Focused on?
Focused on the posts.
Yes.
And I was going to come to what they say in the course of this submission.
Well, you're only doing the first stage of the bank mallet at this stage,
Yes.
aren't you? My point was directed at that.
The first stage of the bank, then at
No,
point
sorry.
about whether or not
Well, I may
There's a
be
measure sufficiently
misunderstanding your
important to-
submissions.
justify a limitation of the protected.
You were going in turn through the bank mallet.
Yes, so we're still at this stage at 1,
Yeah, exactly.
which is identifying, as it were, at this moment as a matter of principle, where the European Court of Human Rights draws the boundary,
Yes.
where
And the
some
words I
interference may be
picked
appropriate.
up from the case you've just taken us to was gratuitously offensive.
yes,
and no contribution to public debate. I'm simply asking, if we're focused on the post, why this court can't reach a view on that, on those.
Well, it can do, but if we focus on the first word, it's gratuitously offensive. I can see that offensive, straightforwardly, is something that lends itself immediately to an objective argument. On gratuitously offensive, so it might be open to claimant to say it's not gratuitous. There's a reason why I'm expressing myself in this highly offensive way.
But that would be would that be? I'm not sure gratuitous means looking at the subjective reasoning of the person who said the words in question. Gratuitous, I would have thought here, meant effectively offensive without any justification for being offensive.
Well, indeed, that even if one takes that approach, it might be open to a claimant to say, but in these particular circumstances, I have a justification. And then that would be a question of fact. But I don't pretend that we're not looking at written documents.
Yeah.
What I don't know, as I said, is what I don't know. What would have been, what points would be made in relation to that. But I do know that if it's remitted, then Mr. Adair or whoever appears on behalf of the claimant will have complete freedom to make whatever points they want to make.
This is a big question which I won't expect you to be able to answer unless the answer is obvious. We're very familiar in purely employment contexts asking classic reasonableness questions with the idea that this has got to be decided by the tribunal, a kind of question which involves an evaluation.
Yeah.
And unless there's only one possible outcome, all that Jaffrey stuff. But if we're in Bank Mellor territory, which you say we shouldn't be, but if we are in Bank Mellor, we're more effectively in public law. These are public law concepts. And there must be quite a lot of jurisprudence, I just at the moment can't remember what it is, about the approach taken, appropriate approach for appellate courts when considering Bank Mellor issues on appeal.
Yes.
And I can't remember where the case law has come down on that. I feel is that it's a bit more willing to let the appeal court make its own decision, or indeed say the appeal court should make its own decision, provided it has all the factual material.
Well, in that case, it's an example of my being in a position where you've forgotten more than I've ever known, because I don't think I know the answer to that question, but I am sat next to a specialist in public law who may well have an answer to that question.
Oh, Lord, I think it's the Dalton case your Lordship might have in mind.
I know it's been looked at. Well, no need to give an instant answer. If someone, I think this is something we do need to be reminded what the principles are. And I dare say they're pretty straightforward. There's a case which states them authoritatively, and it may well be the case Ms. Clement mentions. But leave it for the moment, Ms. Jones, Mr. Jones, and if it's not answered at the end of the submissions, we may have to ask for a note about it, but I suspect somebody will answer it.
Can I invite you then to look at the Lillendall case, which is at page 364 of bundle 7. Again, we're dealing here, if I remember rightly, with criminal liability. So again, I'm not suggesting this is an employment case. It has one similarity in that if you look at paragraph 3, you'll see that the background circumstance involved in a proposal in Iceland to, quote, strengthen education and counselling in elementary and secondary schools.
So, sorry, which paragraph?
This is paragraph 3 at page 364.
Yes, thank you.
On matters concerning those who identify themselves as lesbian, gay, bisexual or transgender.
Yeah.
That produced, it seems, if one looks at paragraph 5, a very offensive statement a result of which, having read, you will now know that Icelandic has specific words for animal copulation. And, but concerns about indoctrination of children, you'll see, appears in the second line. Where the matter of current interest really picks up is at paragraph 33. Where the court is summarising what it thinks of as being two kinds of hate speech. And they are, broadly speaking, looking at 34, hate speech which offends Article 17, that's the gravest sort, and which falls outside the scope of Articles 10 and 9 altogether. But at paragraph 35, a less grave form of hate speech is identified. And if you fall within that category, it's considered permissible for the contracting state to restrict. At paragraph 36, says, into this category the court has not only put speech which explicitly calls for violence or other criminal acts, has held that attacks on persons committed by insulting, holding up to ridicule, or slandering specific groups of the population can be sufficient for allowing the authorities to favour combating prejudicial speech within the context of the permitted restrictions on freedom of expression. And you will see it says, the last sentence, in cases concerning speech which does not call for violence and other criminal acts, but which the court has nevertheless considered to constitute hate speech, that conclusion has, quotes, been based on an assessment of the content of the expression and the manner of its delivery. In this particular case, you'll see at 38 that the language used was serious, severely hurtful and prejudicial. That's the view taken by the Icelandic Supreme Court. And they go on to say that to describe homosexual persons, especially when coupled with the clear expression of disgust, render the applicant's comments ones which promote intolerance and detestation of homosexual persons. And over the page at 375, but still within paragraph 39, it says the manner of delivery of the comments does not alter this conclusion, although it is true that the comments which were made publicly were expressed by an applicant as a member of the general public, not expressing himself from a prominent platform likely to reach a wider audience. So, in that case, you were dealing with someone who wasn't reaching a very broad audience. It says, moreover, viewing the severity of the comments is correctly assessed by the Supreme Court, does not detract from the court's finding above that the comments were not directed in particular at vulnerable groups or persons, and then there's an invitation to compare and contrast another case.
It goes on eventually to find no breach.
Yeah. So that's, as it were, the kind of convention approach. There is an inner limit. Yeah. It falls short of calls for violence. It can include gratuitous offence and insults of the kind that were identified in that case. So the question that we now have to ask ourselves is, could the language in these posts justify any interference at all? I put it in those terms because we come later in Bank Mellat to think about less severe infringements. The question at this point is, could an employer, faced with posts with this language, have interfered with the expression at all, or were they effectively bound to say, you're well within your rights to say what you've said in the manner in which you've said it, with the consequences that might have? And that was effectively the appellant's case in the disciplinary hearing. So these are my opinions and my Facebook, and it's got nothing to do with you. You can't tell me what I can and cannot say. So with that in mind, can I ask you to turn to page 156 of the supplementary bundle, please? think I had the wrong reference. I'm sorry. It's 153.
Of the supplementary
Of the-
bundle, not of the core.
Sorry, of the,
I,
this must be the core bundle.
I
Sorry.
think it must.
Yeah.
These are the posts themselves. They're in.
Yes.
They're in the core. Yeah.
And sorry,
Which page?
153, please.
153. Right. Yeah.
So this is the second of the two posts.
Yeah.
It's in this post that what is described as the quotes perverted vision of gender fluidity is identified as a form of child abuse, and you'll see that language at 155. What we would say is it's difficult to envisage a more serious allegation to make against someone that they are an abuser of children, which is how this is being put.
Well, it all depends on the context. It's not suggesting they're an abuser of children in the physical sense. It's perfectly clear what they mean. It's just heightened language.
Well, I'm not suggesting that they are saying that children are being physically abused, but they are suggesting children are being abused.
Well,
who is identified as responsible for this? Well, if you look immediately below, it says should presumably be LGBT crowd with the assistance of the progressive school system. So particularly identified as responsible for this perverted vision of gender fluidity and this form of child abuse, however one wishes to define it, is identified members of the LGBT community.
These are the views of judybeth.com reposted by claimant.
By the claimant, and which in the course of the disciplinary she seems to have accepted that she agreed with. So I don't think it's ever been suggested that she disagreed with what was in the posts. She, when challenged, suggested that she might not have used some of the language. That's as far as it goes. So this is targeted in the sense that it's LGBT people who are identified as being responsible for this. If one sits back and asks the question, could an employer, faced with an employee who is expressing themselves in this way, reasonably think it was open to them to intervene, we would say it must be at least possible that a reasonable employer might conclude that they would, and that a reasonable
but I thought you agreed earlier this isn't the test. The test is what the tribunal thinks.
Sorry, that was the second part of that
Oh,
sentence.
sorry.
And that a tribunal would conclude that a reasonable employer might be expected to do this.
Well, even that isn't right, Ted. The test is, does the tribunal think? Not does the tribunal think a reasonable employer might think.
Well, even on that test, same thing. So imagine addressing the LGBT community and saying that. And if one asks oneself, is there a likelihood that that would be received as being gratuitously offensive, that there was an element of targeting in relation to them? It's hard to see how one wouldn't conclude that that was the inevitable, frankly, conclusion. But could a tribunal conclude that this language strayed over the boundary that had been identified in the convention cases? We say, yes, it could. And because it could, remission is the appropriate course. But that leaves the question of severity of penalty to come. So at this stage, as I say, the only question is any interference, one that a tribunal could conclude would be justified by reference to the European Convention authorities and in the light of this language. Now, we think also relevant is the fact that although it said this is not being said in school, that's true. But what is also true is she's referring to what is happening in schools, including her own. So
Including what, sorry?
including her own.
I see, yes.
So the brainwashing, her words, although she subsequently said she might not have used that word in retrospect, is brainwashing which she's suggesting is taking place in the primary school to which her children attend, but also inevitably in the secondary school in which she is. Apart, because in the first message she's referring to the UK approach, which involves teaching in both kinds of school. So you're focusing on reputation rather than offence for a moment. Interestingly, every time the question of reputation damage gets considered, the first question is always really, are people who disagree with these views likely to think less of the school as a result of their being associated with her? And that was a point, my Lord, which you raised. Recall you came up with a potential example that was we then moved on from. There can be certainly damage to reputation in circumstances, it seems to me, and a tribunal could legitimately conclude that there was a sufficient risk of such damage in circumstances where one of your employees is sending out messages in terms like this. But there is another side to it which is much less often discussed, which is assume the person hearing it doesn't disbelieve. Assume that someone says, here is a teacher in Farmer's school who is saying, effectively from her own experience, that the children in the school are being brainwashed. The children in the school in which she works, the school I'm here to represent, are having their minds filled with this perverted vision of gender fluidity and are being encouraged by its promotion by the LGBT crowd into a form of mental illness. If that's taken at face value and seriously by people, what's the impact on the reputation of the school in those circumstances? Could a tribunal think this is again, because of the manner, the language which is used, that this is an expression which falls outside what the convention would recognise as being protectable? Well, that's not quite right. What the convention would recognise entitles the state, or in this case an employer, to take some action to intervene. And we say again, the answer is yes. So is the measure, moving on to the second stage, rationally connected with the objective? Yes, we say a disciplinary penalty imposed on someone whose actions risk infringing the rights of others or damaging the school's reputation is rationally connected. Could a less intrusive measure have been used without unacceptably compromising the achievement of the objective? This is where we do get into, I think, some difficulty in relation to factual questions. So the way in which the argument was advanced is, look at what the tribunal has to say about the unfair dismissal possibility. And I dealt with yesterday the fact that there is a range of reasonable responses and it wasn't argued in front of them, etc. But it is worth bearing in mind why the school felt that dismissal was appropriate. You'll see that, I won't take you there because I'm already eating very substantially into Mr. Milsom's time, the particular passages. But at the time of the disciplinary hearing, the messages were still up, so they were still being displayed. There's a specific consideration of sanction, and for your note, that's at page 38 of the supplementary bundle, and the school were concerned that she, quotes, demonstrated no understanding of the implications of her actions and how this may reflect on her professional reputation as well as that of the school within the community within which they serve. And you'll recall, of course, that the tribunal, who was saying who would be obliged to reach this decision, they find at paragraph 62 of their decision at page 103 of the core bundle that Mrs. Higgs had made it clear, this is a quote, that she had no intention of desisting from making further such posts. So those are, we think, all things which the tribunal could rationally take into account in asking itself the question whether some lesser penalty other than dismissal might be appropriate. And in circumstances where an employer has concluded that an employer has misconducted themselves, that they have no insight as to what it is that they have done wrong, and their intention is to keep doing conduct of a similar nature, I don't see how it could possibly be said that it is impossible that a tribunal might conclude that a dismissal was a proportionate penalty in those circumstances. And that also leads into, and I hope deals with also the fourth point, whether balancing the severity of the measure's effects on the rights of the person to whom it applies against the importance of the objective, to the extent that the measure will contribute to its achievement, the former outweighs the latter. That pure balancing exercise, which is identified in 4, again, we say has to be possible that a tribunal taking all those matters into account would reach a decision that would decide the proportionality argument in the school's favour. It certainly isn't so clear that it's open on Jaffrey, on a Jaffrey basis, we think, to substitute. So that, I hope, deals, well, even if it doesn't deal, it's all I have to say about the question of remission. There are 3 other points which I hope I can deal with rather more swiftly before Mr. Nelson rises and simply drags me to the ground. So ground 2 of the appeal is the EAT failed to direct itself or to provide guidance to the EAT on remission on the principle that the Convention protects not only the substance of the manifestation of expression, but likewise the language and the manner. Well, that's in essence a criticism of the guidance which has been given, and I'm not permitted to address you on the guidance, but its specific contents. But what I would say is that Mrs. Justice Eady is very clear that what she's not seeking to do is to give some sort of comprehensive account of all the matters which must be taken into account. She was reluctant, it would appear, to do it at all, but was persuaded nevertheless by the intervener to do so.
Okay. Sorry, I don't want to slow things down, but this is actually quite an important point. I still haven't bottomed out exactly what it was that you were asking for permission to cross-appeal on, and which was refused, because rather unhelpfully, the grounds of the cross-appeal are cross-referred to some other documents which don't. I'm not subject to that. You can't clearly cross-appeal against any aspect of the judge's order.
Yes.
I suppose, yes, that, yeah. I think you're entitled to make observations about aspects of her reasoning, which, I mean, the order is the order and it's quite short. I don't think it is objectionable for you to invite us in our judgment to gloss or modify or add to some of the things she said in para 94.
I agree. I think where it would be difficult is it's paragraph 2 in which she sets out effectively her understanding of Page. I think
Just look at the order again.
Sorry, so we're talking about the judgment, paragraph 94 of the judgment.
Yes, but you appeal against an order.
We do, and the order.
And the
of remission, of
order
course, includes
is in para 1. And it says the matter be remitted for the determination of the question, and then the question is formulated, and you're stuck with that. And then there's a bit in brackets about in accordance with the reasons provided in the judgment handed down that day. I think that's a wholesale incorporation of every word of the judgment.
Yes, except the reason why I was taking the point is the thing I can't appeal, which is the order for remittal,
No,
sets out what I'm going to say is the incorrect interpretation of Page, but so does paragraph 2 of the guidance. So if I were to say paragraph 2 of the
you say
guidance,
paragraph 2 of the guidance.
yes,
What got?
at 94.
94, subparagraph 2.
Yes. Okay. Well, we'll have to. I don't want to slow things down. We will have to we'll have to navigate that as we think fairest to both parties.
Well, I think I can deal with this, Graham, fairly briefly, which is simply to say we don't suggest it would be an error of law if she had included some indication that convention principles make allowance of the fact that there must be some degree of latitude in how views are expressed. Mm-hmm. But there is the boundary that I identified in the course of dealing with the Mellat point. So I'm not sure how it is, in any sense, an error of law not to include a particular matter in guidance which you're giving, which is expressly not intended to cover everything. So I just don't see where this point of law supposedly arises. On the question of ground 3, that's where he was dealing with stereotyping and the question of the adoption of the view of third parties. Broadly, we agree to this extent. Obviously, if you have in your mind, when dealing with an employee, the reason why you deal with an employee is dependent on some stereotype based upon a protected characteristic, then that may lead to a discrimination finding. And similarly, if someone who is a discriminator invites you to do something and you do it knowing that the reason why it's being done is that you're satisfying the discriminatory intent of the third party, that will be an act of discrimination. What I think is difficult here is what is being said to you is it is so obvious that the complainant held discriminatory views, and so obvious that what the school did was adopt those views rather than forming its own view as to the acceptability of the posts, that they are effectively absorbing the discriminatory views and the stereotypically discriminatory views of the complainant. And I cannot see how it could possibly be right at an appeal level to substitute a decision in those circumstances. But it doesn't really get any further than the first step, which is that you would have to decide, the tribunal would inevitably conclude that someone whose identity we don't know, who has never so much as given evidence, and who only appears, his internal state of mind appears only in the form of the email of complaint itself, held discriminatory, stereotypical views, and that those were adopted by the school. That is plainly a question of fact which the tribunal has not determined, and it's hard to see how it would ever determine that case. But certainly, an appeal court is not in a position, it seems to me, to form the view that it would inevitably be concluded from that email that this is someone who is engaging in discriminatory stereotypes. And I obviously don't represent the individual, but I'd be horrified to think that an appeal tribunal or an appeal court would reach a finding of fact, which is what it would be doing, in relation to someone who never had the opportunity to be heard or explain themselves. And that's really what you're being invited to do. And it seems to me that it would be grossly improper. It's not just a question of does it rise to the Jaffrey test. It's just not something an appeal court should be doing, reaching findings of fact about people who are not to be heard. So ground 4 is this question of whether or not Mr. Condon's reasons can be attributed to others. I'm a bit limited in what I can say because it hasn't really been developed substantially.
Sorry, I didn't hear what you said.
So ground 4 is I'm in difficulties responding to because the particular way in which it's put has never ultimately been developed in any detail. But can I suggest that you look at two things? The first is paragraph 61 and 63 of the Employment Tribunal's decision at page 103 in the core bundle.
Which paragraph did you say?
It is 61,
Yeah.
the first instance. So the very first words of 61 are, although not stated as clearly or simply as this. So I know people who are seasoned readers of employment tribunal decisions, what that is saying is, this is This is how I have interpreted the evidence which has been put before me. But without needing to get into the specifics, what you might expect, having looked at that sentence, is if you did go off and start looking at the evidence, what you would find is that the proposition which is set out there is nowhere expressed as clearly and simply as it is in this determination. And at 63, that reason is then attributed to all the decision makers. But the tribunal is telling us that what it has done is listen to all the evidence, read all the evidence, and formed its own view as to what the reason, not just of Mr. Condon, but everyone was. And that, it seems to me, is something that a tribunal is plainly entitled to do as the fact-finding tribunal. And that it's not enough simply to say, here are some selected extracts from cross-examination, or even here are the witness statements, those are before you. You should reach a different conclusion as a matter of inevitability. This is absolutely classically a position in which the tribunal has access, not just to all of the evidence which has been given, but the manner in which it has been given, and has reached a nuanced view. So we say, without understanding the specifics of how it is put by reference to documents, we can't fault what the EAT says at paragraph 80, which is at page 79 of the core bundle. We think it's genuinely an unimprovable approach to it. So the EAT has looked very anxiously at whether or not it was in a position to do what it was being asked to do by the appellant, and it decided it was not. And it decided it was not, for precisely the reasons which I've just outlined, that the tribunal is in a much better position to reach that decision than the appeal tribunal could possibly be. And recognising the dangers that arise from engaging at a kind of appeal level adventure into the evidence for itself. So I suppose that is an incredibly long-winded way of simply saying we agree entirely with what the EAT has said for the reasons the EAT has given, and we invite you to do the same. And finally, I finish, unless there is anything you wish me to add, in which case I will now yield to what I suspect is the red-faced and furious Mr. Milson sat behind me.
Conceding it very well. But do my Lord or my Lady have any questions for? Right, thank you. Now, Mr. Milson, I leave it to you to sort out any grievance you have with your leader. But I can say we found his submissions very helpful. So that deprives you of one weapon to use against him. But that does leave a question about how much time we should allow you.
Yes.
I'm not really clear what you're intending to cover that has not already been covered. I'm not suggesting there's nothing, but I think I would like a clear agenda. And subject to knowing what it is, we will be imposing quite a strict timetable on you, because we have two interveners to hear from, and Mr. O'Dare, I think, tells us reasonably that his reply will be may have to be quite substantial.
Well, my Lady Miller's, what I was intending to address was 5 headings, 2 of which concerning the framework of the Equality Act, and the reason being, my leader's swapped his seat, which is very generous. The reason being that they are the framework by which the intervener's submissions should be considered. And then thirdly and fourthly, I was going to deal with 2 specific problems with the approach of all intervener bar 1, namely that the incompatibility has not been established, still less defined. And then finally, section 3 cannot assist. A lot of that touches on matters that
well, I think quite a lot. That's all. I'm not complaining, but in such general terms, I can't quite work out what it is. But it sounds though quite a lot of it has in fact been covered by Mr. Jones, not because he was intruding on his turf, but because we asked him questions.
No, indeed.
How long do you think you're going to be?
I was hoping for an hour, and that was
You won't get an
pre-agreement. But given where we are, I could be done by lunchtime.
I think you should aim to be finished in half an hour. We will see where we are then and whether we, because I think we ought to make a start on. It won't be the end of the world if you go on to an hour, but I think I need to be looking at sorry, if you won't go on till 1.
Do on.
But I will be looking at my clock, my watch rather before that, and questioning whether these appointments really need to be made. So can you be economical?
I will endeavour to do just that. You have a full response to the submissions of the interveners and their various approaches at Annex 1 to our submission.
Yes, that was helpful.
And you'll be relieved to know in the time I have, I don't propose to go into those in any great detail and take those as read. In deference to from Ms. Fraser-Butlin, I do wish to clarify this. There's an unfortunate typo, and I said that I would confirm this. Paragraph 11, Roman numeral 2, where the respondent says...
So which page are we on?
So that's page 252 of the core.
252, yeah.
Where the respondent says this: the proportionality assessment is not an added burden on the employer, but on the worker. Clearly, that is the wrong way round. Absent a justification defence succeeding. And it's the defence for the respondent to raise.
Sorry, what have you said wrong?
So it's not an added burden on... Worker and employer should be the other way around.
Yes, okay, fine, got that, right.
Other than that, I'll take those as read, and indeed the points of agreement. As I say, the structure I propose to adopt is to address 5 matters. Firstly, the scope of Section 10, definition of the protected belief and its consequences. Secondly,
just don't worry with headings. Just okay. Scope of Section 10. What are you going to say about that?
My Lord, the definition of belief in Section 10 is broad. It includes any religion and any lack of religion, or any belief and any lack of belief.
I'm sorry, I'm not going to be picky at all, but there isn't any issue about the scope of Section 10, is there?
Can I just explain the
All
relevance?
right. Well, why is this relevant?
Because discrimination complaints or protection is afforded to the worker who holds that belief, the worker who holds a directly opposing belief, and the worker who holds no belief at all. The reason I raise that is this: it is very much the same territory of countervailing or rival protection, which is the genesis of separability in the Fessett decision. Because what Lord Justice Elias said there is that there must be a role for separability where there are rival assertions to protection. Just because one person is a whistleblower doesn't mean that another isn't. Paragraph 53, volume 5, page 287. Lord Justice Elias observes that it cannot be assumed that the first to blow the whistle necessarily deserves the fullest protection. The reason I raise that is that when considering the full rigour of Bank Mellat, it has to be, and indeed whether a Section 3 reading is possible, it has to be borne in mind that there are rival claims to protection. My second heading was this, that 4 features of direct discrimination. We're concerned with a direct discrimination claim. The late application to include an indirect discrimination claim was refused by the tribunal, not because of the merits of that claim, but due to the proximity to the hearing and prejudice in such a late amendment. My lady asked whether PCPs could be identified in this case. The claimant identified PCPs.
Do we have? Is this in the case management ruling, which I haven't looked at?
It's a case management ruling with, all I have as to the reasons is counsel's note. It was no reasons were requested by either party. But you see the redactions to the...
Sorry, do we have this case management note?
It's in the supplemental hearing bundle, I believe.
No, I think I saw it, yes.
Yeah. But what we don't have is the reasons for So we have the case management order.
Yes, I see.
Page 2. The amended pleadings we see in the core bundle include the pleadings that will include the PCPs that were advanced, but not allowed to be pursued to a full.
Anyway, you were going to make a point about the PCPs.
Well, my point was this: it's not beyond the wit of the claimant or anybody else to identify PCPs in this case. PCPs were identified. It's simply that they weren't tested. The definition in section 13 will be very familiar to you. A person A discriminates against another B if, because of a protected characteristic, A treats B less favourably than A treats or would treat others. And the framework of the Act, of course, is having identified the protected characteristics and then identified the prohibited conduct. The Act goes on to identify when the duty to avoid such prohibited conduct bites. And this is an important point when it comes to Section 3 and incompatibility, because Section 13 does not simply apply to public bodies. It applies to the private employer, to individuals, to agents, principals, knowing helpers, aiders and inducers. There may be a pre-existing relationship between claimant and putative tortfeasor. There may be none at all. Take the present case. The decision makers on dismissal comprised a panel of 3 governors, each of which acting in a voluntary capacity, but nonetheless as agents of the school. The claimant could quite properly have chosen to include those individuals as respondents on a joint and several basis, or even to pursue claims solely against those individuals.
Yeah, I got the point, yeah.
And the reason I raise that is on the Section 3 question, as in Mercer, how far does the duty to
As in what, sorry?
As in Mercer, the Supreme Court decision of this year, beginning of end of last, the reason why a Section 3 reading was impossible is because there was a range of choices available to the legislature, and the court could not be in a position to identify how far either the incompatibility went or the interpretative exercise went with it. In other words, does full-blown bank mallet apply just as much to a claim against an individual as it does to a public body?
Yes, I see.
The basic principles of direct discrimination, well understood distinction between the criterion and the mental processes case, and we're squarely in the latter camp. We identify the general principles of
Are we? Suppose an absolutely straightforward case in which someone makes a declaration that they are a Christian, and the employer says you are dismissed for being a Christian, or there was a rule no Christians allowed. Christians being obviously that would be a straightforward criterion.
I'm not saying for a moment that belief claims are incapable of being, in the abstract, are incapable of being criterion cases, but the present case...
This is almost a dismissal for being someone who doesn't believe in gender fluidity.
That's not the way in which it was advanced in the
No.
first
All right.
instance,
Okay.
and it's not the findings of the tribunal. In
No.
the present case, we are dealing with a case which has always been pursued on a mental processes
very well.
basis.
Okay.
That being so, I would emphasise 4 features of the mental processes claim in the world in which this tribunal operated, a decision handed down in October 2020, pre-page of the Court of Appeal, Feb 21. First, causation in a Section 13 case is understood to be a pure question of fact. I'll give you references rather than take you to the review of time, but Lord Brown Wilkinson, paragraph 24 of our submissions, Natarajan, page 136 and 137. The only yardstick, as Lordship said, in the field of direct discrimination must be the mental state of the alleged
Wasn't Lord Brown Wilkinson dissenting in that, or
Not on that. Lord Nichols did not dissent
Anyway,
from that.
okay.
If we look at page 139,
Don't worry.
on that there was
I don't think it's a controversial.
dissent on outcome, but not on
Yeah. All right. So causation is required rest of fact. Second point.
Second, that yardstick is not subject to an objective benchmark of reasonableness, rationality, or proportionality. Zafar, Volume 2, page 27 of the Appeal Bundle. Just as applicable in the successor legislation, BAL EAT, paras 93 to 94, Volume 3, page 81.
Yeah. So you can say my reason for doing this is not religion, it is this, and this might be something wholly unreasonable, but if it is nevertheless genuinely your reason, then that is the cause of the action.
Exactly so.
Yeah, okay.
And critically linked to that, the same approach is taken to separability. I don't repeat the submissions on Kong.
Yeah.
You'll be familiar with those, of course, in your previous judgment of Martin and Devonshire. A critical and sceptical eye is necessary, but that is not the same as imposing a proportionality assessment. To address the question of my Lord Justice Bean yesterday as to the J.K. Rowling example, if there were, for example, evidence that an employer took a lenient view towards those expressing gender identity beliefs and disparaging J.K. Rowling, but came down rather more heavily on those who expressed the converse beliefs, that is the sort of thing which the sceptical and critical eye of the tribunal should be alive to. In such a case, a tribunal may well conclude that the reason for treatment was the belief itself, if certain manifestations are tolerated and others are not. That is not on the material before the tribunal or in its findings, this case. Third, the focal point...
Fourth, surely. Third was separability as a question of fact.
No.
Oh, sorry.
First was question of fact. Second, subjective, not that yardstick being subjective, not subject to a reasonableness assessment. Third, the focal point of the discrimination claim is upon less favourable treatment. It is a model of formal and not substantive equality. Unlike sections 15 and 21 say, there is no requirement to treat individuals more favourably. I don't obviously repeat anything that Mr. Jones has said on Liddell and McFarlane. Important to record that both of those decisions were upheld by this court. Master of the Rolls, then Lord Lombard, is saying that the judgment of Mr. Justice Elias was plainly right. And likewise, neither of those cases received permission from the Supreme Court to go any further. Indeed, it's worth noting in the McFarlane permission decision, a rare decision on permission which was reported and therefore could be relied upon, that Lord Justice...
That follows, but we go on.
That Lord Justice Laws said that Liddell was an inevitable consequence of Natarajan, Paris 13 to 14, Volume 5, page 81. In none of those cases did the ET or the Court of Appeal go on to say, right, so the reason for it is manifestation and not the belief, but the manifestation response must then be subject to a justification defence, a question of prescribed by law and reasonable necessity. And so it's wholly unsurprising that the tribunal in the present case did not make findings on proportionality because there was no claim before it which required.
Oh, that's obvious. We know they didn't because that's not the basis on which they decided it.
Indeed.
Okay, well, stick to the new points.
And final proposition as to a fundamental feature of Section 13. There must be a complete statutory tort in the mind of the decision maker. Reynolds and Naylard, Reynolds, Volume 6, page 83, paragraph 36, which identifies that it is fundamental to the scheme of the legislation that liability can only attach where an individual employee or agent has done an act which satisfies the definition of discrimination. The reason I raise that is this. when it comes to an objective assessment, whose knowledge is the reference point for that proportionality analysis? Let's say it's clear before the tribunal that a lesser sanction might have been appropriate because someone historically or prospectively was treated differently for similar reasons. But that was totally beyond the knowledge of the decision maker. Is that which is a finding of direct discrimination to be founded on things which are not known to the individual decision maker?
Well, it can't be right on justification, can it? That disproportionate treatment by an institution because other people aren't treated the same way is nevertheless not to be taken into account because the individual decision taker didn't know about it.
Well, why would that feed into a Section 13 claim?
Well, it's you who's raising the point.
Yes, the reason I raise it, my lord, is this: if there must be complete liability in the mind of an individual decision maker, how can that be reconciled with a proportionality assessment based on things that they are unaware of?
Yes, I see.
Now, with those four principles in mind, it's my submission that any of the submissions of the interveners must be read in the context of those principles. And so too, in my submission, must Page. One presumes, not least because Liddell and McFarlane were cited by my lord, that Page itself did not intend to depart from authority binding on this court. And rather importantly, this court has, in Kong, concluded the ratio of Page does not incorporate a bank malus analysis. Because were it otherwise, why was such an approach rejected in Kong? For this reason, we agree with...
Show us, we were referred to Kong earlier, but can you show us in Kong where it says, if it does, that that's how Page should be interpreted?
Well, it might be a submission of reasoning from silence, as it were, but in the sense that what the court does not go on to do is accept the need for the behaviour to be unreasonable or subject to any other yardstick.
But aren't you just making the same, and I don't mean this critically,
no.
But you're making the same point that Mr. Jones made, that the relevance of unreasonable behaviour or disproportionate behaviour is into whether the particular, quote, separable belief was genuinely held.
Yes.
In which case, I have that point, and that was very clearly made by reference to Kong.
Yes, yes, but the reason I raised Kong, because I think it fell to me to say prior agreement, was that I would say something on the ratio of Page in the context of the intervener.
Yes.
In the interventions. That is one of the reasons why we say that the Commission is right at paragraph 10 of its supplemental submissions to contend that all that paragraph 68 of Page sets out is the need for critical scrutiny as to whether the reason is genuinely separable. But that's critical scrutiny within the parameters of the mind of a decision maker, not by reference to an objective bank malus test. That being so, I turn to the range of approaches you have before you from the interveners. The Archbishop's Council adopts the guidance of the EAT as containing practical tools for a tribunal and guidance that employers and employees can understand. The Free Speech Union seeks to widen the scope of a protected characteristic to include the manifestation unless the manifestations are, quotes, so obviously inappropriate as to justify restricting them. That's paragraph 6 and 9 of the FSU submission, pages 88 to 89 of the supplemental bundle. The Association of Christian Teachers laud the principle of free speech as being foundational in nature, but it's unclear what particular approach you're being asked to do with that. And Sex Matters suggests that all manifestations should be incorporated into the protected characteristic, and hope that the rarely successful genuine occupational requirement defence serves as the sole.
Oh, sorry, you're telling us what they said, which we've seen. What's the point you're making?
Well, I'm about to turn to it.
What?
What none of those interventions address is the fundamental prior question, which is blending necessary, and to what extent?
Sorry, is the what necessary?
Is blending necessary between the
Blending,
Convention
yes.
and the Equality Act? And if so, to what extent? And the word blending is invoked from Miss Fraser-Butland's submissions. Unless this court determines first whether the Equality Act is incompatible with Convention rights, and if so, how, the Section 3 exercise is a thing written water. We know as much from Donahue, on which Ms. Clement relies on her supplemental submission. For the note, it's volume 2, page 295. Unless the legislation would otherwise be in breach of the Convention, Section 3 can be ignored.
Yeah.
See also Benyon, volume 9, page 483. As Lord Justice Elias put it in Land Registry and Grant, paragraph 44, volume 5, page 117, the fact that the law must be interpreted consistently with the rights found in the Human Rights Convention does not mean that Convention rights must be actively promoted whenever a statute falls to be construed. And we say there is no basis advanced by any of the interveners for the incompatibility in the first instance, particularly in view of the features we identify at paragraph 49 in our submissions, and 6 matters in particular, and I'll go through them quickly. Firstly, the range of different practices within Council's signatory states. Those are set out in Ouida and Begum. Secondly, Strasbourg...
Sorry, what are these 6 points going to demonstrate?
That it is inherently unlikely that the orthodox application of Section 13 is incompatible with the Convention. And absent a finding of incompatibility, that Section 3 has no role.
Okay.
Secondly, Strasbourg had the opportunity to review compatibility in the conjoined applications of Ouida, Liddell and McFarlane, but it didn't do so.
Yep.
It endorsed Begum, it recognised the margin of appreciation afforded to signatory states, paragraph 84, volume 5, page 386, and had no issue viewing from Ouida and the other decisions from the prism of indirect discrimination. As Lord Justice Morris Kay observed in Umber, the Strasbourg decision in Ouida was, quote, entirely fact-sensitive, paragraph 20, volume 6, page 21. Third, prior to the Employment Equality Religion or Belief regulations, there was no freestanding right to bring a claim of discrimination for belief before the EAT. Is it being suggested that for 50 years, the absence of protection was incompatible with Convention rights? Fourth, in the passage that Mr. Jones took you to, my Lord concluded in McFarlane, when President of the EAT, that there was no incompatibility in the demarcation between direct and indirect discrimination. 5, the Convention does not require the remedy to take the form of a direct discrimination complaint. This is territory which was explored by this court in Gillam, and the suggestion that the absence of whistleblowing protection for judges was a breach of Article 10. And at paragraph 87 of that decision, a decision in this part that the Supreme Court did not overturn, paragraph 87, volume 6, page 524, noted that whilst there were advantages in bringing a whistleblowing claim before the tribunal, that's not an answer to the question of whether Section 7 of the Human Rights Act, in addition to other protections, does not afford an adequate remedy. The authorities bundle is sagging under the weight of various judicial review decisions relied upon by the claimant, or decisions as to wrongful or unfair dismissal claims where convention rights have been invoked. Why is the orthodox application of Section 13 and the simple application of factual causation incompatible with the convention? And sixth and finally, the Act already provides a more natural home for the issues raised by the manifestation cases, namely indirect discrimination. The total silence of the availability of indirect discrimination in the submissions of the Archbishop's Council, the FSU, and the Association of Christian Teachers is notable. The Sex Matters intervention does address indirect discrimination and maintains that at first blush, Article 9 qualifications might be more, quote, apt to align with indirect discrimination. See paragraphs 31, page 149 to 150 of the supplemental bundle. It suggested that there is some problem, however, due to the group disadvantage requirement, a requirement which this court considered in the case of Gray and concluded that there was no incompatibility in the group disadvantage requirement with Article 9, and in any event seeking to dilute it would be an impermissible use of Section 3. The consequences of the interveners to fail to first address the incompatibility issue takes them to very strange places. And that's evident in the approach of the Archbishop's Council, by way of illustration, to separability. Separability is recognised as valid by the interveners, such as in Kong. Paragraph 27 of its intervention, page 66 of the supplemental bundle. No challenge is raised to Kong, and it said, quotes, that the question to be answered is subjective. The sole question is what the employer believed. When it comes to belief discrimination cases, however, the Archbishop's Council contends, quotes, that an objective analysis of the employer's subjective reason is required. That's paragraph 60, page 76 of the supplemental bundle. It's wholly unclear to the respondent why a different approach to separability should be taken in some convention cases, Article 10, whistleblowing, Article 11, Morrison, Metrolink, than others, such as in the present case. Why is Article 10, which was invoked by the EAT and the claimant and the interveners, any more foundational in nature in a belief claim than it is in a whistleblowing claim, where the public interest is engaged? So we say, firstly, in response to the interventions, that there's no basis on which incompatibility is identified. And secondly, if there is, it's wholly unclear what the scope of that incompatibility is said to be. That leads to the fourth subheading of mine, which is, are the various readings under Section 3 possible? Even if my Lady Justice Falk were right that there are issues in identifying PCPs, does Section 3 entitle the rewiring of Section 13 of the Equality Act? And we say there are two fundamental problems with a Section 3 reading, however it's proposed by the interveners. Firstly, that it goes against the grain of the legislation, and secondly, that there is more than one option available. As to the first, 3 of the 5 interveners accept that imposing a proportionality assessment does go against the grain of the legislation. Sex Matters, the EHRC, and the Free Speech Union each recognise as such. See paragraph 4 of our Annex 1, pages 248 to 9 of the core bundle. The respondent agrees with the FSE, with those interveners, that a fundamental feature of the legislation is that applying the reason why question is a simple question of factual causation. Indeed, we note the terms in which Sex Matters puts it before the court. Paragraph 25, page 147 of the supplemental bundle, says this: Section 13 contains nothing resembling the Article 9.2 ECHR objective justification test, and effectively reading such a test into the Equality Act would go against the grain of the Act and undermine the principle that a conforming interpretation should not result in judicial vandalism or damage the scheme of the legislation or its essential principles.
Goes against the grain, yeah?
Indeed.
What's the second? Second fundamental.
I was just going to deal specifically with the question you, my Lord, raised as to the FSU suggestion, widening the scope of the protected characteristic by incorporating pre-justified detriment into the protected characteristic itself. Not least because it's an approach which is commended by Mr. Adair. It is problematic for three reasons. Firstly, it falls into the same approach that the FSU rightly recognises as going against the grain of the legislation, because it simply undertakes a justification exercise at an earlier stage. Secondly, justification by reference to what? If a court or tribunal is being asked to pass judgment on the manifestation, it's inimical to the secular principles recognised by the House of Lords in Williamson. And if it's justifying by reference to the treatment, it falls into the same problem which Mr. Cooper recognises goes against the grain of the legislation. And the third problem is this: it rewrites long-established principles on the correct hypothetical comparator, which have been upheld by this court. Asme and Kirklees, Liddell, Johns and Darby, Page before the EAT, which, as I understand it, was not disapproved by this court, all take the view, and indeed Grace Places for Children, all support the identification of the hypothetical comparator as somebody who behaves in precisely the same way, but for reasons unmotivated by their beliefs. So that the approach urged by the FSU is one which would take this court in a manner contrary to decisions binding upon it. It would also contravene the less favourable treatment focus, which is obviously one of the four principles guiding Section 13 I've already set out. The second reason why this is so problematic is the range of options open to Parliament. My lords will recall the case of Mercer, in which the Supreme Court found that the absence of protection under Section 146 for detriment short of dismissal contravened Article 11, but the no Section 3 reading was possible. And indeed, the range of options proposed by the interveners indicate the range of options which Parliament might take to remedy any identified incompatibility. Indeed, there are others. The alternative may well be a positive statutory duty of reasonable accommodation, or something akin to Section 15, which puts the focus on the proper place, but also removes the stigma of a direct discrimination complaint focused upon the individual decision maker. And the fact that other attempts to dilute the strictures of Section 19 have been tried and failed, as in Gray, is no answer to the dead end under Section 19, if there is one, to distort the meaning of Section 13. We would also say this is an intensely sensitive policy area, and the unintended consequences must be borne in mind. The interveners praise the importance of creating a space for difference and fostering tolerance. But incorporating a strict proportionality assessment is liable to have the opposite effect, because the employer will be in a better position to impose a strict neutrality rule than taking each case as it's found and hoping that people behave respectfully towards one another. It's for this reason we say that the failings in the alternative interventions only serve to reaffirm the two central propositions in the EHRC intervention, namely that direct discrimination is to be considered on an application of a pure test of factual causation, unshackled by a proportionality analysis. And secondly, as a consequence, manifestation complaints are better viewed as instances of indirect rather than direct discrimination. The attempts of the interveners to either perpetuate or build upon the imposition of proportionality take the law still further from the four principles I've identified. My Lords, my final heading was two areas, if this court is minded to provide any further guidance, two further areas of guidance which, if the court does feel able to address, would doubtless be of assistance, not just
Let's hear what they are.
cases. The first is the application of the prescribed by law precondition. Page says nothing as to this test. And how it applies in a Section 13 claim is not altogether clear. Of course, the test is addressed to the signatory states prescribing law, not employers or individuals. To what extent do we say, is it said that the prescribed by law test allows
Yes,
for
I
an
see.
honest
So what you're really
mistake?
saying is the prescribed by law test is inapt to this kind of case.
Quite so.
Yeah. Well, I think that's probably enough to say. I've got that point.
And then finally, when assessing proportionality, whose knowledge is the appropriate reference point? So,
Yeah.
If the individual is wholly unaware of the circumstances which make conduct no longer prescribed by law or no longer proportionate, for example, resting on the assumption that training is
The point you
provided,
made earlier. Yes.
how does that operate, mindful of Reynolds and the other three principles I set out? My lady, my lords, that was a whistle-stop tour, but I hope
No,
for some
thank you.
reason-
I'm sorry
I completely understand.
to have put you under some pressure, but there's a lot of meat there, and we've made full note. Thank you very much indeed. Does either my lord or my lady have any questions? Well, look, I think the sensible thing would be to take a slightly early break. Can we just review where, if each of the interveners were to take the full 45 minutes which they have been allowed, and assume for the moment that this won't be the case, that we don't start again until 2, that will be that will get through to 3:30, which would mean that Mr. O'Dare had, well, I think we could both reduce it to 4:30, but would have an hour left for his reply. Likely to be enough, Mr. O'Dare?
My lord, I'm unsure, because this case has been a roller coaster of endless surprises with submissions knocked back by skeleton arguments, and I still wait to see what Miss Clement has to say.
Very well.
And I'll do a serious point to that. I would like to raise the possibility of our being allowed to submit a closing note following the close of play.
Well, you can raise it. You won't get an immediate response from us. For obvious reasons, we don't like it. But sometimes it is the right way forward. So, but whether it will be in this case, we're not going to make any promises. I think I just wanted to get your response, because you are the party here. The interveners are only the interveners. My lord and my lady will discuss over lunch whether somewhat to curtail the time available to the interveners. The interveners, I think, should use the lunch break, such part of it is they're not eating their sandwiches, to work out how, if we insist, you take rather less than the 3/4 of an hour, which you thought you were going to get. 5 to